See plenty of folks coming in. We're going to give it just a couple minutes before we get going as folks begin to trickle in. All right, we'll go ahead and get started. First of all, welcome. Glad you're here, spending maybe your lunch break with us. Before we get started, I just want to remind you to be sure to check out Beasley Allen's event page. We're doing one of these webinars every third Wednesday of the month. And so if you join us for each of the 12 months, you'll get 12 hours, including an hour of ethics, CLE. Next month, our topic is going to be protecting consumers from dangerous products and fraud. It's going to be hosted by D. Miles, Allie Hawthorne, James Eubank, and Leon Hampton. They'll be covering some stuff dealing with class actions, whistleblowers, securities, and PBM and insurance. Also, I'd just like to add, if you have any questions at any point, you can use the Q&A feature here on Zoom. We'll be certainly taking questions at the end if time permits, but if I'll be manning the question box over here, and so we'll try to get all your questions answered. I haven't already, but I should introduce myself. My name is Gavin King, and I'm joined by two of my colleagues here who have practices that are really devoted to e-discovery. Elliot Bienenfeld, who works with me in our toxic exposure section, where he leads our discovery efforts, and Suzanne Clark, who is his counterpart in our firm's Mass Torts Section. And so we're going to get going here. I'm going to start by giving you just a little bit of a roadmap for the things we're going to cover today, and then I'll throw it to those two to really help us all learn, while we as trial lawyers don't really have to be scared of e-discovery anymore. So here's the roadmap. The first thing we're going to talk about is data in your daily lives. We're going to define ESI. We're going to talk about just discovery generally and how e-discovery fits in. EDRM. We're going to talk a little bit about proportionality, practice pointers and considerations. And then, of course, at the end, we'll take some questions. And there may be a pop quiz or two throughout just to help understand some of the points that we're making. So pay attention to those. I don't think we have any door prizes, but you get a gold star from all of us. So with that, I'm going to kick it away to Elliot and Suzanne, and we're going to talk a little bit more about e-discovery.
And Gavin, real quick, if you don't know what either ESI or EDRM stand for, I promise you by the time this presentation is over, you will know. So,
and you would be just like me about a year and a half ago. So,
and also there are some really bad puns sprinkled throughout this presentation. Please don't blame Gavin or Suzanne for it. That is, I'll take sole responsibility.
All right. I'll kick it off a little bit here. When we were thinking about planning out this webinar and e-discovery made simple being the idea, I was thinking about what do we want to do, and what do we want to teach our fellow attorneys about this? And e-discovery and ESI, electronically stored information, can be intimidating and complex because it's an area of science and data, and we're used to the law. But I think about it like judges in federal court will have science days on a complex mass tort where everybody, all the lawyers and judges need to learn about the science and what the experts are going to be saying. And so it's the same thing with ESI and eDiscovery. What we're doing is we're taking electronically stored information and the way data is today in our world, and we're applying the rules of discovery to it. So these are the rules of discovery you learned in law school, you practice all the time, but now we're just taking a technical look at it and then bringing in the law. I don't know if you had anything more on that one, Elliot, but
no, it's just, I just remember coming out of law school, eDiscovery was a black box. It's sort of like how I treated math throughout my whole life. I just was scared of it and just assumed it was difficult, but it's not. Sometimes complicated terms are thrown around, I think, just to make things sound more impressive or scary than they are. I do think it's incumbent upon every litigator, though, you don't have to be an expert, but really be able to be proficient and articulate in basics of what we're going to be discussing today. So that's sort of part of the point of this. Go ahead, Suzanne.
Okay, stats. You want to go over some of these?
Yeah, sure. So I put this together just to show everyone, there's not just emails out there, and there's a ton of stuff generated all the time everywhere. So I'll just riddle these off. On average, every human created at least 1.7 megabytes of data per second in 2020. So that's 6.5 billion people times 1.7 megabytes times 60 seconds in a minute, and you get the
megabyte, gigabyte, terabyte.
Yes, byte, kilobyte. It's
right.
It's like decimal points, right? So you have, and think of bytes as the atoms of a file, right? It's what comprises the space that takes up a file. So you have a byte, a kilobyte is 1,000 bytes, a megabyte is 1,000 kilobytes, a gigabyte is 1,000 megabytes, and a terabyte is 1,000 gigabytes, and then you can go on from there. Why that matters, why you care about what gigabytes are, et cetera. Frankly, a lot will come into pricing if you're dealing with vendors or anything, or just in terms of your own storage. The size of data compressed, zipped up in a container file or expanded is really going to play a big role in prices you pay. So especially if we're getting off on a tangent already, but but if you're ever looking at
that's an important thing for attorneys.
Yeah,
and you hear gigabyte and you say, what does that even mean? Mm-hmm. And that's usually the first level of pricing. Mm-hmm. Mm-hmm. So a minimum of a gig, and then after that, and then how much is a gig? I mean, when you do the right click on properties in a Word document, it's going to tell you how many KBs are there. It's usually 1,000, 2,000 for a Word document. So once you're getting into gigabytes, you're starting to see, 1,000, 2,000, a few thousand emails, or not so many pictures, because pictures are larger, but you get charged by them.
And we can get into that, but all data is not created equal, right? A text document or an email is much smaller. It takes up less space than, let's say, a video, right? A 30-second video could be 6 times as much size as a 300-page Word document. But all right, let's stick to, So all that, you guys all read those facts. That was just sort of to give you a sense, again, of just the enormity with which we are dealing in data. We're drowning in it. So go ahead, Suzanne.
So then what we were kind of just to spin off of what we were saying, you've got all different kinds of electronically stored information. So we're talking about emails and photographs, Word documents, spreadsheets, JPEGs, PowerPoints, videos, calendar invites. I mean, we're just reading it off, but Peloton stats is on here, your Fitbit, and then moving on to the next. And these slides will be circulated to attendees if you just like to have a list of these things. Dropbox, where are files being shared, and the Ring, somebody's Ring on their front door video, ephemeral data, Snapchat, what's going on with that, who's having conversations where, things like that. So, so those are ESI sources, and all of these can be measured in gigabytes when you're looking to collect and host this kind of data.
And one big point on this, we put this slide together to sort of illustrate that. The previous one was to show you the volume, or the previous two, and then this slide and the other slide, if you go forward again, are just to show you that, you know, when someone talks about producing data to you, don't just look for emails, or don't just look for you know, a share file of some PDFs that people scanned things to you. Data is everywhere and in everything. There's something called the Internet of Things, IoT. That's where, so Nest, Ring, Peloton, all that, these are capturing individual data points and sort of frankly using it to better market products to us, but still they are items that capture data, which could be of incredible use to your case. Think like a black box in an airplane, right? That's what we're talking about. So that's a source of data that isn't what you normally think. Like in trucking cases, the geolocator, et cetera. Those are pretty important.
Yeah, and we'll talk about this a little bit later, but you know, looking at all of these things, just when you're thinking about requests for productions in a case, these are things that you ordinarily wouldn't come up as a trial lawyer. You know, I'm not thinking about these things sometimes, but you don't want to narrow yourself to maybe just the emails or just the computer that you know your defendant might have. You need to be thinking about the whole universe of just the wide array of places where information is stored now.
Exactly. And there is a specific limitation on ESI where in Rule 26 about whether it's reasonably accessible or not. But this goes to show you, especially on the plaintiff side, that don't let folks tell you things aren't reasonably accessible, because they will use that as a boilerplate excuse. It's cheap, it's available, it's easy. It's easier than they will pretend it is, I think.
Especially your sophisticated defendants.
Yes.
They've got it.
Yes. In my previous life, that was what I was paid to do, is confuse plaintiffs' lawyers and make it seem like they were asking for the moon. So,
and also the federal rules of civil procedure do not define electronically stored information, because the rule drafters knew that it was going to change over time. And when the rules were changed in 2006, electronically stored information was added with the definition of document. And in 2015, there were a lot of rules amendments, which we'll get into later, regarding electronically stored information. But in 2015, I don't think, you know, for example, Snapchat was prevalent. It may have been, but
we're old, Suzanne. I don't know. I don't know.
The point is, it's always changing, and the rule drafters realized that. So you don't have to request, I want your Snapchat data. It's up to the producing party to determine where responsive and relevant information is. And we'll talk about that. But you ask for the electronically stored information related to the subject matter that you're seeking.
And that, real quick, we're getting off on a ton of tangents, but that brings up a really good point as well, where the law here is not, the technology is fast outpacing the law. So in a certain sense, you know, EDiscovery is sort of its own Wild West, right? You're never going to get a statute that defines exactly what ESI is, exactly like Suzanne said. So it's up to you as the lawyer to craft your argument about why something is relevant and necessary to your case.
And proportional, accessible, et cetera. And so this just delves a little more into what we've already talked about. So we will move forward. Oh, metadata. I remember my first EDiscovery conference in 2014. I was doing doc review and I got interested in EDiscovery, and I went to the Association of Certified EDiscovery Specialists conference in Hollywood, Florida. And somebody said, well, metadata, everybody here knows what that is. And I didn't. And I had to look it up. So let's talk about metadata, because it's such an important part of ESI. You want to tell us what that is, Elliot?
Sure. So it's, I mean, the phrase that people love to say, it's it's kind of on point. It's data about data, right? So it's, if you pull up, think of, you have a Word document, you right click on it and you pull up the properties tab. It'll tell you generally, you know, date created, last modified by the author, et cetera. You could really, and that's just on your regular, you know, within Windows, there's advanced metadata, but basically every application and program that you run tracks everything, every time, every change pretty much. And it's stored away, and it's easy for the program to do that, and it's necessary for folks to sort of follow breadcrumbs back about, you know, who created a document, where it was stored, et cetera. I think it's a really important point where if you look at a document, don't take the document at face value. You have to see, that's why I like this iceberg picture. That's just the tip of the iceberg. There's so much that you can know. There's so much I personally in my own practice have figured out. I've found names of custodians. I'm like, who is this person? Why were they writing this? And then we get their documents because you pull on threads. So these basic examples that are listed here are, again, just the tip of the iceberg in terms of metadata. There are all kinds of metrics that, depending on your program, are tracked, right? So like Peloton metadata will be very different, I think, than you know, PowerPoint metadata, but
Right.
This is the bread and butter of what eDiscovery is about, I think.
And I agree. I was at a CLE many years ago, and the presenter said, it's like having a picture of a steak or actually having a steak. You know, we're talking about evidence here. Electronically stored information is evidence. You don't want to take your robust piece of evidence and turn it into near paper. So if you're PDFing, if the producing party is PDFing all their emails, they are taking away the robust metadata, the information about the document, and they're giving you a PDF. Now, you may think, well, I'm probably not going to look at those things and this and that, but there's software out there and document review platforms that will take it for you. And there's artificial intelligence already built that computer scientists have built based on litigation, where if you get one of these tools from a vendor, it will take the good production in that has your metadata, or it'll analyze the text. So you want to make sure you have good extracted text in the production, and it will give you timelines. It'll give you graphs and pictures and Venn diagrams of who was talking to who when. Sometimes you can even press a play button and see the timeline and watch the cast of characters change over time. You can identify gaps in date ranges easily. You can see the custodians. I like to scroll through file name metadata. So I'm not even looking document by document. I'm pulling a search. I'm selecting the metadata fields, which are like columns. Documents are rows, and scrolling through and just looking at file names and spotting keywords about my case and key ideas about my case through looking at the file name metadata, or original folder path metadata, which is human decision often about where something was filed. So that's like getting the manila envelope and the documents. Where did this person want to file this? Did they want to file it in their, urgent folder? So then you can just look for the urgent folder and look at that first, especially when you're receiving an incoming production and you need to investigate and find out about your case that way.
Yeah, and I know we're going to talk a little bit more about how some of this stuff fits more broadly. But as somebody who, coming out of law school, I've never heard the word metadata. This stuff is invaluable for taking depositions.
Mm-hmm.
I mean, you just, showing up with documents and just having the documents is one thing. But if intimately about, when that document happened, not just the date the person wrote on it, when it was created, where it was saved, who all had access to it, you can really get a deponent on the ropes real quick. And you can let them know pretty quickly that you know a lot about this document. So at bare minimum, they better be honest with you. And if they're not, there's a really, it's easy for you to begin to paint the picture of them being dishonest. So,
That's a great example, Gavin.
Yeah.
Who all had access to that document? So you can take an attachment, and it would have an MD5 hash, which is a fingerprint of a document, and it's a series of numbers and letters. And then you can say, for that exact duplicate, I'm pulling all of those. Now I'm going to pull the family and email threads associated with that, and I'm going to see who all saw that attachment quickly. And then if that's really helpful in depots, I agree. Okay. Rule 34. ESI.
And we base this off of federal rules because it's good boilerplate, but obviously if your state will have individual, basically should mirror this, but there will be slight differences. But for uniformity, we just use the federal rules here instead of, say, Alabama.
Yes,
So
there's always comparable rules. So, this is just Rule 34, which is your document requests. So it's your request for production rule, and it also brings in Rule 26. So with Rule 26, you're looking at scope. Scope of discovery has changed. It's no longer likely to lead to discovery of admissible evidence. That got stricken out of the rule. So judges really don't like it when we if attorneys say that anymore. So now it is three things: relevant, not privileged, and proportional. And then there's 6 proportionality factors, which have to do with the burden and expense, how important this is to, public policy. There's 6 proportionality factors. Won't get too much into that. And then Rule 34 is your request for production, where it says you can specify format of production. That's where you can ask for your metadata and say, I want that. Is there anything else we want to talk about with the Rule 34 here?
No, just that it's sort of central to your doc request now. There is, again, we touched on it, there is a specific carve out for ESI where if it's not reasonably accessible, then.
And we will get into the rules later in that.
Yeah, and we will get into proportionality too. Don't worry.
Right. And mainly, electronically stored information is distinct from e-discovery. That was something I wanted to bring up with this slide. So electronically stored information is the evidence, and then electronic discovery is really just discovery. But now we're having to fold in the fact that we've got technical issues associated with ESI. So that's more along those
that's sort
lines.
of
Yeah. Got a little ahead of the slides.
All right, we won't take long here. Pop quiz. I know you're all practicing lawyers, so you hate the phrase pop quiz, but bear with me. I'm getting ready for clerk season, so we're doing a lot more of these. You're reviewing opposing party production. You see a memo relating to key facts with a date of June 10th, 2017. Printed on it, the key date in your case is June 22nd, 2017. What other info about this memo should you be interested in? And the hint there is think metadata. So I'm not going to make you all raise your hands. Just be thinking about, we spoke about metadata. What other things might you want to know about that document from June 10th?
Well, is it from June 10th, Gavin?
Right.
Yeah. It's just because you have a printed out memo and it says, date June 10th, 2017. Is it?
Yeah. I mean, and again, if you got the metadata, you have an opportunity to look at that, and who all saw it, when it was actually created, who created it.
Right.
Yeah.
So what we're sort of trying to, I'm sorry, go ahead, Suzanne.
Oh, when it was modified.
Yeah.
And then you can look for near duplicates and see if you can get drafts and red lines and things like that. So there's going to be different types of date metadata. There's going to be created, last modified, and emails, date sent, date received. Then an attachment could have different date metadata than the email, but it will also have date metadata associated with the email and when it was sent, its parent document. So there's a lot of places to look, and it's often, there's some difference between date received, date sent, and things like that. That could all be helpful to your case.
Yeah, and you mentioned something right there that I've come up with in real life. Seeing different versions of a document. So drafts of a document, you see that somebody made an edit somewhere. Oftentimes people don't make edits for no reason, which is again, just a good field of inquiry and depositions. Why was this, from the metadata, why was this sentence changed? What was the reasoning behind that change? Do you know? So yeah. All right, next question. Besides emails, what are 3 potential sources of ESI? The answers there. The answers there are
about our favorites.
Yeah.
My favorite right now is ephemeral data.
And what is ephemeral data?
So that is data that does not last, that goes away. So, we think of, you tell your kids anything that you do will now be videotaped and posted online. And when you try to get a job in 10 years, they're going to go find it. So there is that issue with ESI where it stays forever. But then there's the ephemeral data, which goes away quickly. So if you're talking about Snapchat's my favorite example of this, where I know a lot about it because I have teenage children, not because I use it, and then we might have clients that use it. So when you're Snapchatting, you are typing, and it's like, I say it's like a phone call was to me in the 1980s is what Snapchat is to kids today. So if they're snapping and Snapchatting, if I was in a litigation in the 1980s, would I suddenly stop using the telephone because I might say something that's relevant and responsive to the litigation I'm involved in as a teenager? So can we ask clients that are teenagers to stop using Snapchat? But there's the idea that you trigger a duty to preserve once you're in litigation or once you anticipate litigation. So how do we deal with that? Then there are ways to capture a Snapchat conversation, but the other people you're talking with are going to know that, which could be a problem with your friends, right? If you're suddenly saying, I'm in litigation, and so I have to capture our messages. I've researched it. Snapchat does not keep data. It goes through their servers. They don't store anything. So that's the issue. Now, if you're in an intellectual property case and you've got people using Snapchat to talk about the litigation, that's a problem, right? So, so that's my favorite form of ESI right now to try to figure out. What about you?
I'll go with one real quick. So with the pandemic, a lot of companies obviously are working remotely, and the rise of collaborative software is going up. When I'm talking about something like Teams, where you'll have channels, that Teams or Slack, where you'll have channels where you can have messages stored, and more importantly, documents created and stored. That's a whole new kind of thing that people are grasping with right now. So Teams data, catch the fever.
Oh, good. EDRM. Okay. So we're both going to talk about this one, but the electronic discovery reference model was created, I'm trying to remember when, but it's been a while. And it was started with corporations who were in litigation and they're dealing with information governance. And we have all this data, and how are we going to deal with this data throughout the litigation life cycle? So Elliot, I'll let you get into each stage of the EDRM, but I just want to talk about how when you're in the beginning, you have a large volume and low relevance. So you see the triangles on the screen. So you start with all the data, and as you go through the litigation life cycle, you're going to identify responsive data. That's going to take your volume down, but your percent relevance is going to go up. You're going to preserve data, collect data, and as you go along, all the way to production and presentation, you will have a much smaller amount of data that you actually produce, and even smaller that you actually present at trial or hearing or mediation. But the relevance will be really large by then.
Mm-hmm. Yep. So that's the volume relevance sort of axis on the bottom. Information governance is sort of not really germane to our discussion here. That's more for in-house general counsel, making sure your business records are kept properly according to state and federal law. We won't get into that. So, but it goes exactly like Suzanne said, sort of an inverted, like a funnel. where the volume goes down and the percent or the ratio of relevant documents goes up, so that by the time, if you're collecting from, think about the Enron litigation, I guess. Gavin's too young to remember that, but the Enron trial, that was millions of pages, millions of documents. And then by the time the trial comes around, there's 600 exhibits or something. So, yep. So that is, but the EDRM is really what, when Suzanne and I wake up in the morning, we look at a picture of the EDRM model and we govern our lives by it. But really it is, I don't know. That's how you should approach everything in discovery, in terms of always be as broad as possible on collections and preservation, which we'll get to. So it's a two-sided, there are two sides of that coin, but then get down. And there's not only does winnowing extraneous data reduce costs, it saves you time and gets you to the merits of the case faster, because it used to be people will drown you in paper. Now people drown you in electronic documents. That's 100% a tactic.
So we start towards the left, and the first thing we have to do is identify the ESI and potentially responsive information sources. So they call it information governance, and that is absolutely a corporate-based idea. But when we have consumer plaintiffs, I think of information governance is what I have myself, right? So I have an iPad, an iPhone, I have my personal laptop, my work laptop, I use Dropbox, Google Docs, things like that. That is my information governance. And it may have absolutely nothing to do with any litigation I'm in, but those are my places. So we've got to get with our custodians and get with the people that know about our case and identify information. And so I think we have some practice pointers coming up. If you want to
there's a phrase that you may have heard, it's called data mapping or creating a data map. What Suzanne just talked about, that's essentially what a data map is. You talk to everyone in your enterprise, what devices they use, what data they generate, what data they inputs and outputs, basically, of external data coming in and work product going out, and then you catalog it so that you're able to immediately identify who has what. That's ideally what corporations should do.
And then identification practice pointers. So do you want to talk about this, Elliot?
Yeah, and so this is on the client side. We're going to do, like I said, it's a flip two sides of the coin. So this is, you need to collect documents from your client to fulfill your discovery obligations. I think the biggest thing I could possibly say to this is document your process in writing. Always, and this will be addressed at a couple more points in later slides, but just keep a contemporaneous list of what you're doing, why you're doing it, who you talk to. It doesn't have to be pretty, but just something so that there's a defensible, sort of breadcrumbs that you can go back to. Snips, like screenshots of sources or things that you are choosing to collect or choosing not to collect, are invaluable at this point, because you need to make sure what you're doing really in terms of identification for your client's data, it's defensibility. That's what we want, protecting any claims of potential spoliation. So it's really just being as above board as possible. And I have found unless it's a massive company, it's much better to have a single point of contact with your client, who will be able to, turn on and off the automatic deletion / initiate the legal holds, handle file transfers, wrangle custodians for you, etc.
And then if we're dealing with consumer clients, we can do client interviews, client questionnaires. Again, that goes both ways. If you've got a big corporate client, you're looking at, departments, and then you're looking at people and all that. But I mainly deal with consumer clients. So if it's a smaller case, we'll do just telephone interviews and go through a questionnaire with them and talk to them about what devices do you have, what accounts are you using, things like that. And then, does anybody else have access to those? Do you think there's any responsive information on those? Interview them. And then if it gets larger, like a mass tort, we could do a questionnaire that they can fill out. That'll save us some time. And then we can go through the questionnaire with them quickly after they've already had a time to think about it on their own time. So we document that. That is our number one. This has to be done. Now, we'll talk later about collections and things like that, and how to do that defensively. And if you want to get a vendor, and that's just a case-by-case judgment call based on your litigation and proportionality and things like that. So, but yeah, we talk to your client, and they're the ones who know, and find out what they've got. You definitely don't want the other side finding out they have an Instagram account and you didn't know.
Correct. So you mentioned real quick a questionnaire. That's something that Beasley Allen has, and we use on our larger, when necessary, really, our larger cases. If you have any questions about that, feel free to ask. But it's a really important, like an integral part of any large identification process.
Right. Opposing party identification. Right. So you want to, I have people ask me, how do I know I got everything? Well, you don't, and you don't have to get everything. The rules say it needs to be defensible and reasonable. But if you're concerned, how do I know the other side's doing this? Because it's work product when you're asking your clients these questions, and these interviews and these questionnaires are work product. How can I feel comfortable the other side's doing that? For one thing, you can meet and confer, or just, that's 26F in the federal rules, but in state, you can always have, let's talk about what's going on with our case. Let's talk about the ESI and talk about data sources. And what data sources does your client have? And I'll give you my client's data sources, and I'd like to know what your client's data sources are, so I know what to look out for. And if you've reviewed their Facebook and don't see anything, then that's your job as the attorney, and you're an officer of the court. But I'd kind of like to know what's out there. And then another concept is a 30B6 deposition, or a records custodian deposition, regarding the information sources. So that's the idea that a corporation is a person. And so if your opposing party is a corporation, it's a legal person, and you have a right to depose them about how things are set up at the corporation. So you could do a 30B6 deposition about their information sources. And you'll hear defendant corporations often say that's discovery about discovery. Now, like I said, if we're talking about, we want to know about your litigation holds and your client interviews and things like that, yes. But if we're talking about your modern day filing cabinets in your data map, we get to know about that too. That is an integral part of what ESI is and what is discoverable, to the point that it's now in a comment to the rules. It used to be in the rules, but they said, this is so obvious, we don't need to clutter up the rules with this. You do have to exchange information sources.
And I'm a big fan of this 30B6 depo for custodians. I've used it recently. It wasn't a document intensive case, but for anybody who's ever been filed a lawsuit, you get some objections back when you ask for things, just kind of boilerplate objections. This is overly burdensome. This is too difficult. We don't have it, blah, blah, blah. Just to get somebody who would have knowledge about where stuff is kept and ask them, how difficult would it be to get it? And in my example, it wasn't a document intensive case, so it didn't involve ESI, but just to ask, hey, do you have this? And the answer is yes. And to say where, it's like, oh, it's just in a file cabinet back here. How long would it take you to get it? Not long at all. Okay. That kind of deposition gets rid of, when you go to ask for your RFPs after that, they can't tell you that it's too difficult to get, because you've already got it on the record that it's not that difficult, or that they have access to it. And so it's not an original idea. I've heard it before, but I just really, I'm a big fan.
You're implementing it, and that's great.
Yeah, it is. It can really cut through a lot. And also, real quick, if you ever do receive boilerplate objections, that's literally, I think in the 2015 amendments, it's literally revised to, you cannot, a boilerplate objection to discovery is not sufficient. It has to be stated with
particularity.
Yes.
Yeah, you have to state with particularity what your objection is. So I am objecting because this is overly burdensome. I would have to go to the warehouse, pull out the backup tapes, and it would cost me this much money to have Iron Mountain do that. This case is only worth $10,000. You know, I mean, you really actually do have to say what the burden is.
Yeah.
And you can't just say, judges are really not liking the boilerplate either way. The any and all coming from requesting parties, or the boilerplate overly burdensome, overly broad, not proportional, you know, blah, 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 privilege, but it might not be privileged. They're just saying that they don't like those, they'll strike them. If there's blanket objections at the top, which is a preamble, you're supposed to state with particularity for each request why you're objecting. So you can't just say, I'm objecting because these might be overly broad, and then I'm incorporating my, you know, qualified responses are also not permitted. I'm incorporating my preamble objections to this objection. No, you have to state why. And if you've withheld under the federal rules, Rule 34B to C, I always have to look it up. If you withhold, that's part of the specificity thing. You have to say, if you've withheld, you can't just make all these objections and then none, or produce some things and not others. You have to say we did withhold based on those objections. Preservation. Legal holds, preservation letters. I'll let you start it off, Elliot.
Sure. And I realize we only have about 20 minutes left, and I don't think we're making great progress. So we'll fly through this quick. Preservation, hope everyone notices the cool dinosaur DNA preserved in the amber. That's why I put that there. So it's a cool picture. Anticipation litigation. On the plaintiff side, pretty easy. Pretty much as soon as you're retained, send out legal holds. I cannot emphasize enough the importance of sending out a legal hold. Send out legal holds to more people than you think you need to, because it's better. This will probably come up on a later slide, but it's probably better to be cautious. At this phase of litigation, you're really just trying to sort of CYA, right? You want to just prevent any potential claims of spoliation. So you can always take people off of the legal hold, but it's way harder, almost impossible, to retroactively put someone on legal hold that should have been on. So send it out and really follow up with your clients to ensure that it has been has been sent out to everyone that it should be. An easy way to do this that I've done is I've sent it out via email, and then they have to acknowledge, like, the read receipt kind of thing. It's sort of invasive, but it's makes sure that the person has received the legal hold and accepted it. Alternatively, you could just have people check a box and return the legal hold to you, so that you keep track of everyone who has reviewed it, received it, and acknowledged it. So.
And there's litigation hold tracking software for if you have a corporate client and things like that you can use. And you know, there's a system for make sure you've sent it, make sure they've received it, make
reminders,
and then reminders throughout, and then release it at the end. Because the tip there is you don't want to have them continue to hold something that would have been on auto delete, and then have another litigation that it's relevant to, and it would have. Now you have to review it for the new litigation, and that's very that's costly for corporations. I don't think about corporations as much as I used to, but this is an overarching CLE. So preservation practice pointers, auto delete, backup tapes. You know, if you have corporate a consumer client, they could have it where they want to keep their iCloud data down because it starts to get fees. So they may have auto delete on things for after a year, like text messages. And so you need to ask them about that and make sure that they stop that. But with, you know, IT departments, things are auto deleted off of emails, sometimes after 6 months, if they're still in the inbox, or if they're not forwarded or not foldered, or, you know, there's all kinds of records retention policies. And the issue with records retention policies is that if you have them, courts expect you to implement them. And litigation hold policies are usually part of the records retention policy. Is there anything else on this slide? I know that we wanted to keep moving.
No, I think.
Hey, I know we're about 15 minutes out, and I know we want to talk about proportionality. So maybe let's get through some of the stuff, get to proportionality, and then talk about some of our general considerations and try to leave some time for questions too.
Perfect.
Okay. Okay. We can skip through collection.
And we are sending everybody who's on here, you can get a copy of our slides. So there's a lot of information on there you can see. And so please read through it if you'd like.
One might say too much information.
Right.
A lot. Okay, proportionality. Perfect.
Okay, so as we said, Rule 26, scope of discovery, you're looking at relevant, not privileged, and proportional to the needs of the case as being what your scope of discovery is and what needs to be produced. So again, it's not everything, and you aren't going to be sure that you got everything. So do you want to talk about the 6 factors, Elliot?
Sure. So I'll read them off, and then we can. What's interesting about these is they're all sort of weighted equally. I don't think there's one that governs more than any other, generally speaking, which is, so it's interesting. And you'll see courts do the 6-factor test and come out very differently on different things, which is interesting because people can, I mean, it's so fact specific. So the importance of the issue is at stake in the litigation. So is it a dog bite case, or is it, opioid litigation or something? The amount in controversy, is it $15,000? Is it 35 million? The party's relative access to relevant information. That's a big one, because a lot of times the bigger party will just say, well, you can access that yourself or something, but the smaller party, usually the plaintiff, has less ability to it. And it's really actually ties into the party's resources. It's time, money, ability. So that's number 4. Number 5, the importance of discovering and resolving the issues. This is actually a big one in terms of, a lot of people will raise issues that, oh, I need this. And then you really boil things down. It's like, well, why do you need John Smith's, calendar from 1986? I think you're just trying to make a fight about discovery. So, I mean, what would providing this discovery help towards resolving the issue? And 6, whether the burden or expense of the proposed discovery outweighs its likely benefit. You can see that they're all they're similar in idea, right? It's weighing cost benefits, and the proportionality was meant to make things more efficient and cheaper and more fair. I'm not sure how well that the 6 factors are doing in that regard, but that's sort of the idea behind it.
And if you are objecting, or your opposing party is objecting and says something is not proportional, they are actually supposed to say why. And as Elliot said, it's a fact-based assessment. And so they should give facts as to why this is not proportional in their responses to requests for production or interrogatories, or et cetera, et cetera. So, so you actually want to, it's boilerplate if you just say not proportional. You need to say why. And then, you may even have affidavits involved in that and things like that if it's going to go to court. So if you're saying it's going to cost, I think about costs a lot with proportionality, especially when it's fact, because that's even more fact-based, right? That's just dollars and cents. So if you say, reviewing these documents, we're going to be paying the attorneys $150 an hour, and it's going to take them, 2 months to review, and we're going to have a team of 15 attorneys. And then you're saying that's how much it's going to cost. I would want to know that's your argument, because I might say, actually, why don't we talk about limiting it to 3 custodians, and let's negotiate some keyword searches. And what are you talking about when you're talking about this volume? And are you using email threading and deduplication and other things that can save you money on attorney review? Because we skipped through, the rest of the stages of the EDRM, but attorney review is the most expensive stage. So are there ways to cut down on expenses by reducing the amount of hours attorneys are going to need to review? Like there are so many tips and tools and techniques. So if my opposing party is saying not proportional, I'm saying, are you shopping around for your vendor, or are you just finding one vendor? Because I think you're paying too much per gigabyte, things like that. So moving forward.
All right, let's talk about just some general considerations. If you got kind of a document intensive case, if you're like me and you're generally kind of thinking like a trial lawyer, and you're trying to learn a lot from folks like Suzanne and Elliot every day, these are just things that I'm kind of thinking about. So, you need to know how this works within the framework of the federal rules. So Rule 16, the scheduling order. I know a lot of judges who just kind of give a stock scheduling order in civil cases. You might need, it might not be workable if you've got a lot of, documents, and you're discussing how, how you're going to ingest and review a bunch of documents, or the opposing party has similar concerns. 26, scope. We just talked about proportionality, but obviously you also got to be thinking about privilege, relevance, burden, things like that. Rule 33, interrogatories. Want to be considering how these, the things you may need to know might be different in a case where there's a lot of electronically stored information. I brought that up earlier. That there are obviously, just from the, the large, group of places where ESI is held, that we discussed earlier, it may not be in the normal group of questions that you ask in your interrogatories. Same thing with the RFPs and Rule 34. 37, Rule 37, look, we hate to imagine lawyers behaving badly, and people, getting rid of, documents and information, electronically stored information that you should have, but it happens sometimes. And then Rule 45, non-party discovery. Just like any other case, you need to consider what information you're going to need from people who aren't parties to your lawsuit. Let's go next slide.
Real quick, also, a lot of time you'll get just a non-party subpoena for your client,
Sure.
Right? That's really, I think that so, and a lot of times they'll send a real mean looking, scary email or letter with fancy letterhead saying, you must do this, you must do that. Read up on Rule 45, because if you're not a party, your discovery obligations are frankly, well, they are less than if you were a party. So,
and then with Rule 37, you don't necessarily have to have bad faith. It could be inadvertent, but your duty to preserve had triggered. So we're not talking about bad guys. We're talking about people who make mistakes and attorneys making mistakes, and just trying to make sure you're getting all of that preservation documented. And then you can also, that one's, it's laid out in the rule, the factors that the judges are going to consider with spoliation sanctions.
Yeah, some more general considerations. This is important, and I've been on both sides of this. Sometimes, talk about not necessarily bad behavior, but just in document intensive cases, sometimes mistakes are made, stuff slips through the cracks. The parties need to be in agreement about how that will be addressed when information that should not get out does get out. I've even seen documents come up in depots, or I've been reviewing documents from for a deposition. On the other side, we've been produced something, and I'm just looking at it. We need to be in agreement on both sides about how that information is going to be handled. The next thing is, make sure you read protective orders carefully. Be cautious about what you agree to. And if you've got serious concerns about something in a protective order, or you're seeing something for the first time, don't be afraid to call one of us to talk about it. But make sure that you know what you're agreeing to, especially if it's going to be entered as an order.
Real quick, not every case needs an ESI protocol, but I would say almost every single case needs a protective order, look over that thing. People will give you, generally speaking, you know, the boilerplate protective orders that opposing will give you is okay-ish, but don't rubber stamp it. Look it over, and always have a protective order in place.
Yeah.
And you can always negotiate things like, you have 10 days to give us back anything. I might need 3 weeks for that.
Yeah.
You know, how big is your document production going to be? I'm going to have to go sift back through it. And because of your mistake, I have 10 days. I feel like 10 days is a punishment when a judge gives us 10 days to do something. So I always say, let's make that 30. You know, we'll stop using it, but I have other things on my to-do list besides correcting your mistake, you know. So you've alerted me and I'll get it back to you in a timely manner. And then ESI protocols, you just read them. You know, we're attorneys, and so read them and say, what am I going to have to do? Or what are they going to have to do? And does that seem reasonable? And is that working for my case? So I think this one we've talked about a lot since we're running out of time, just reiterating the litigation hold and ESI sources and making sure you're getting documents from your client. So I think we can move past that one. And then we're on to some general considerations.
Yeah, some of this, you know, I know I'm talking to a lot of trial lawyers, it's common sense, and you can read a lot of this, but you know, you really want to focus in on the docs that are going to help you prove your case. And so who are the people who are going to be responsible for the documents or the information that you would need to prove up, you know, and what time period would they have them. And a lot of that too, a lot of that information that you already know can be helped by metadata that we've talked about earlier. Another thing that's mentioned here that I think is important, when it comes to search terms, remember that the other side has to produce relevant material, and you don't know their lingo. And one of the silly examples I've given in the past is, if you're from where I'm from, you may use the phrase Coke to explain soda, but if you're dealing with a company who's working up in the north somewhere, they may be using pop. And so if you're asking for soda or Coke, it could become problematic when everybody up there is talking about pop. So make them tell you what terms and produce relevant material. So
we have a question.
Yeah.
I don't know if we want to try to take that real quick.
Yeah,
when a defendant says that information has been deleted in accordance with its document retention policy, is that information really gone? And then following that, what are some good follow-up questions to defense counsel to determine if the information could still be accessed by the defendant or some third party? So great question. Is it really gone? It depends. You know, so if it was deleted, it could be on their backup servers, and then you're getting into accessibility issues and also them correcting a spoliation. So it's not spoliation if nothing bad happens, if there's no consequence, which means if they can go find it and get it to you, it's not spoliation. So the questions to ask, I would just go with the who, what, when, where, why, how. You know, just think, okay, where was it? Was this sent to duplicate custodians? You know, if it was deleted here, is it deleted there? What are your backups? How long do you keep backups? Because sometimes the backups can be kept for a really long time.
Do you use an external vendor to handle the physical tapes that are the backups of the backups? Yeah.
Could this have been a part of another litigation? Could this be on some law firm servers? Could this be on a vendor servers for a different litigation? So yes, it might still be there. And if that doesn't answer your question, then you can email us and we'll try to.
It's going to get pretty technical. You're going to want to know what software they're using, and what server, like, are they on AWS as their backup servers? Do they have something in-house that they're using for backups, etc. So that is the answer, as Suzanne said, is it depends, but that's a really good question. It's a response I hear all the time, like, oh no, we don't have that anymore. Yeah.
Probably.
I don't. We've got a question here about general considerations. We'll send out the slides to everybody as well. So if you got a question about information that was on a slide, we'll be glad to send it to you. We're bumping up against our time limit. Suzanne, Elliot, y'all got any parting thoughts before I close this out?
Just to say, it's a big topic that some people either find scary or boring or some combination of the two. Yes, that's what a lot of opposing counsel is sort of banking on, that you'll just get bored of it or not pick at it. And this is where a lot of cases are won and lost, probably more lost than won. So being able to be proficient in it, or at least know who to go to that is proficient in it, is a giant advantage. And I would say don't be scared. Don't if somebody talks authoritatively to you, like, oh, here's our boilerplate ESI protocol. We use this in all our cases. Don't take that as gospel. You have the resources to back that up, I guess. So, yeah.
Yep, I would say you don't have to do it yourself, but you need to have somebody on your team, or if it's a scalability issue and you have a small firm, you can bring in vendors on a case-by-case basis and get the technical expertise you need. So it's available to you. You don't have to know all this yourselves. Beasley Allen, we have 2 Discovery Counsel attorneys, but they are out there if you need help, that you could have co-counsel relationships and things like that, or vendor relationships to help you.
Mm-hmm.
Yeah, all good stuff. Listen, thank you everybody for tuning in. Sorry we went just a little bit over time. Remember to sign up for our other webinars, and also please keep up with us on Facebook and Instagram and LinkedIn. And last thing, if you
Gavin, which also generate tons of metadata. So
tons of metadata. If you ever have any questions though for us about eDiscovery, or maybe you've got a sophisticated plaintiff and you've got a lot of documents you've got to produce, or a lot of ESI, or you just have questions about some briefing on some of these issues, please let us know. We'd be glad to be good friends and help you out any way that we can. And
rising tide lifts all boats. And if the plaintiff's bar ups its game with ESI and eDiscovery, that's good for everyone, for our clients specifically.
Rising tide.
That's exactly right. I mean, I think there are folks banking on us not being able to handle some of this. And so, it's going to become an increasing part of all of our practices. And so we want to be helpful where we can. So please do reach out to one of us. We'll be glad to help you. And with that, I'm going to close this out. Y'all have a good rest of your day, and thanks for tuning in.
Thank you very much.